Hello, my name is Emily, and I am here today with nationally recognized authority and trust clause litigation, Dan Dalton. So Dan, why does the local church have to pay to leave the denomination?
That is a question we get every day. The denomination, as you know, in your annual conference provides no funding to buy land, to build buildings, maintain buildings, insure buildings, or operate buildings, or operate the local church. It doesn't make a lot of sense that they would have to pay to leave the denomination. But the denomination is going to rely on the Book of Discipline and suggest that based on the trust clause under section 2503 of the Book of Discipline, that a payment has to be made.
Dan, what is the trust clause?
So the trust clause originally was called the model deed, developed by John Wesley and through some of his attorneys back in the 1700s in London. And the original idea was to have a meeting place that was open to Methodists to meet. At that time in the 1700s, there was a law in England called the Commincle of Charles that would not allow people to meet for religious purposes, or they would be subject to arrest. In other words, it would have to be 5 people or less. And if it was 5 people or more, or I guess 6 people or more, then you would be arrested. The Church of England was the only thing that was exempted from that. And there wasn't really a Methodist church at that time. It was individuals who went to the Church of England that were falling under the teachings of John Wesley. And the fear was that these individuals at these meetings would be arrested. So the model deed was created so that individuals could meet at these meeting houses throughout England, and they wouldn't be arrested. Fast forward a few years later, when Methodism went to the United States and Wesley talked to Francis Asbury and others about issues within the United States, and in Baltimore the Methodist Episcopal Church was formed, the model deed came over in the form of a trust clause. And the whole idea there was to have a meeting house, to have a place for individuals to worship, and that meeting house would be subject to different theological provisions of in statements of faith of the Methodist faith at that point in time. It was never intended to be a yoke on local churches or a obligation that local churches would have to be subject to if they decided to leave the denomination. It's just developed that way over time. But the trust clause comes out of the Book of Discipline, and that's what it's about.
So then is the trust clause enforceable?
Really depends on what state you're in. So you're going to find some states throughout the United States, about half of them, where states use what's called neutral principles of law, which is going to allow a local church to leave. And when I talk about neutral principles of law, what a court does is it looks essentially at the state trust code and says, is this a valid express trust? So there's 2 types of trust: an express trust and an implied trust. An express trust is what you would kind of think of as a trust document, like you would have in estate planning, where it outlines what you own and where things are going to go to, and it's signed by both parties and who are the donors, and witnesses sign it, and you're typically good to go. An implied trust is a judicially created trust, where a judge will essentially enforce what's called a constructive trust, so that there's somebody that doesn't have the mental capacity to make decisions, or is young, under 18 years old, or is under influence of drugs or alcohol, or whatever the case may be. The court may impose what's called a constructive trust on those, and that would be an implied trust. At the end of the day, what a court's going to decide is this Book of Discipline, this trust in the Book of Discipline, is it enforceable as an express trust or an implied trust? They're going to look at the deeds, for example, to see, is the language in the deeds that say the property is held in trust to the United Methodist Church, is that enforceable as a trust or not? In some states it is, and in some states it's not. It's just simply a state-by-state analysis. And that's something that we do every day and analyze, and we can certainly help you with making that decision.
Dan, what is the pension obligation?
So under 2553, which is the what was passed in St. Louis in 2019. It's kind of interesting if you just read that. There's just really three things that occur during that time of what happens when a local church leaves. So 2553 provides that the church has a conference and 2/3 vote, and they can go. After that, the annual conference has to come up with a disaffiliation agreement, and is to use the standard disaffiliation agreement developed by the General Council on Finance and Administration, which, as an aside, no conference uses the standard form at all that I'm aware of in the United States. And it provides that the agreement allows for the annual conference to develop payments. One is apportionments under 2553, which is 12 months prior to disaffiliation and 12 months after disaffiliation. Other is property, which is the transfer of property. Another is what's called pension liability, which is defined as, quote, the local church shall contribute withdrawal liability in an amount equal to its pro rata share of any aggregate unfunded pension obligation to the annual conference. And this is under 2553. As you know, from other things that we put out in terms of our blogs and our prior YouTube videos, there is no unfunded pension liability. Westpath, which is the one that creates the aggregate number, will tell you all pension plans in the United States are actually overfunded. So it's basically the way to think about a pension obligation is an exit fee. That's all it is. It's a chunk of change or cash to pay the conference so that you can leave. That's all a pension obligation is.
Well, thank you for your insight, Dan. If your church is interested in hiring our firm to help you through the disaffiliation process, please reach out to our office at 313-859-6000 or email us today. Thank you.